Hello everyone, my name is Caitlin Rance and I'm doing my Vulnerable Populations Part 2 on Dispute Resolution in Special Education. So for this, in the video there are several different types of dispute resolution talked about. There's IEP facilitation, mediation, resolution meeting. This is where the school district must hold a meeting within 15 calendar days of receiving notice of a parent's due process complaint/hearing request. Parties have up to 30 days to work on a resolution prior to the hearing. Then we also have written state complaint. Complaints must be filed within 1 year of the date when the individual knew or should have known of the problem. Written decisions must be issued no later than 60 days from the day the complaint was filed. This is no cost to the complainant, and all expenses are cut of the investigation and decision are provided by the state or by the public. We also have due process complaint and hearing request. This is under the IDEA. The due process complaints must be filed within 2 years of the date when the party knew or should have known of the problem. Written decision must be issued within 45 days from the end of the resolution period. The hearing officer or administrative law judge facilities are provided at public expense. And then this is where each party pays their own expenses, which may include attorney fees and witnesses. So the IEP team or even the parents of this child may decide that they want their attorneys to talk for them or have people come forward and talk what the child may need or what needs are being filled and how. Due process is considered the most adversarial dispute resolution process. So this is the more severe process or resolution that can be done. We have also expedited hearing request. This is a resolution meeting that must occur within 7 calendar days unless parties agree in writing not to have a meeting or to use mediation instead. The hearing timeline proceeds if the issue is not resolved within 15 calendar days, and the hearing must be held within 20 school days of the request being filed, and a decision must be made within or issued within 10 school days of the hearing. From these types of dispute resolutions, there are two different approaches, which these can be broken down into as informal approach and a formal approach. The informal approach is more when the family and school disagrees with each other and needs someone who is not an IEP team member, but is there to keep the IEP team focused on developing the child's program while addressing the conflicts that as they arise. The two that fall under this is the IEP review and facilitated IEP meetings. And then under the formal approach, this is where the family and school still can't come to an agreement and needs other ways to resolve the conflict. This can be done with mediation, with where the parent and the school sit down with a impartial third party. Both sides have to be voluntary. It cannot be used to delay or deny a parent's right to due process or any other right under Part B of the IDEA. Must be conducted by qualified and impartial mediator trained in effective mediation techniques. The biggest one I found was that the state must select mediators on a random, rotational, or other impartial basis. The state must bear the cost of the mediation process. An agreement reached by the parties must be set forth in a written mediation agreement. So whatever has been agreed upon needs to be written down and signed. Decisions that occur during the mediation process must be confidential. They may not be used as evidence in any subsequent due process hearings or civil proceedings. So, like, they can't be, if a parent takes a school to court, these proceedings cannot be used in that type of situation. The parties to the mediation process may be required to sign confidentiality pledge prior to the beginning of the mediation. We also have the state complaint under formal approach, and this is written directly to the state education agency or the SEA. The SEA must either resolve the complaint itself or have a system in place where complaints are filed with the school district and parents can have the district's decision reviewed by the SEA. This also must be resolved within 60 days. Then we also have due process. A complaint, which is a complaint, the complaint must include specific information as the child's name, the address where they reside, the name of the school they are attending, description of the conflict, and a proposed resolution of the conflict to the extent known and available to the person filing the complaint. A new concept or idea was from Pacer Center under the communication tab. It was that advocate effectively at IEP team meetings. In this article, it was tips for turning difficult conversations with your child's IEP team into productive conversations. So most parents struggle with bringing up concerns about their child's needs due to the fear that they won't be heard. Some ways this can be avoided or help mitigate issues is before the meeting. If a parent is nervous, they can ask someone to go with them that they trust. So, like a family member who can feel confident as your advocate for your child, or a friend who can act as extra set of ears and take notes for the meetings and help you follow the discussion. And then someone from the community who knows your child can talk about their strengths and can help the IEP team understand how to bring out the best in your child. Some things during the meeting that can be done is getting the information you need. So, like, if the parent is confused about the IEP meeting, they could ask the IEP team to slow down and explain again, or let them know that you're confused and ask them to rephrase what they are talking about. If you are still uncertain about something being said, ask questions and ask for specific examples. Share your concerns this if this can be changed in the IEP services or anything else. So, like, if a need that is not being met for your child, ask if it can be changed. So ask how changes will meet the child's needs. Addressing issues. If you have a problem, bring it to your child's IEP team. Let them know that you've noticed that having a list up on the wall works well to support your child at home and like daily tasks, and ask if this could be used as a strategy at school. Problem solving. If a staff member states they don't know the answer, just ask them who can we call or invite to a meeting to help us find out the answers. And then working with the team, a staff member on the team expresses something you think might be an option. So if they think that this strategy might help your child better than one that they already have in the IEP, just ask them how to help you understand their reasonings behind that. Ask them for data or anything that shows that this is successful. Planning for the next steps. Once you reach an agreement about a change to your child's IEP, or if something is promised to you by the school staff, ask if can we agree on a timeline to make this happen? So when can these changes occur or be put in place? Team disagreements. If at the end of the meeting the team says no to a change you are asking the school to make to your child's IEP, or if the team has not persuaded you about a change to your child's IEP that the school is proposing, you can just simply say, I feel like the school isn't hearing me and I don't agree with what you're proposing for my child. What do we do now? If you feel that your relationship with the IEP team has been harmed by disagreements over your child's IEP, you can just simply state that I know we have had some disagreements. I'm grateful that you're here today to support my child, and I'm hopeful that we can make good decisions for my child together. And then one way that I've seen this policy somewhat is with my two cousins who have autism. They've both had IEPs. For a while, when they were in elementary school, the oldest, who is severely autistic and nonverbal, he never actually really interacted, if at all, in normal classroom settings um, due to being very aggressive and not being able to communicate. While the other one is still very autistic, he is verbal and can communicate a little better. So he could interact in normal classrooms as long as there is an aide present to communicate with him and for him. When it came to reviewing their IEPs, I was actually never present, but I would hear about how meetings would go and the outcomes. I think one IEP meeting that I have heard about with my cousins that did not go so great is with talks of both of them not being able or not being welcome to come back for the following years, which was surprising to me as the school that they were or are attending is specifically for students with mental and behavioral disabilities, but they could not handle two boys with severe autism. After my aunt had a mediator in place, which was one of her friends that actually works with the boys to try to help find a resolution for them. Um, they were, for the education they deserved, they were able to somewhat find a solution that I know of. One thing that was um, a requirement was that they could no longer ride the bus to and from school as it was a liability issue. The rest, I'm not completely sure on how that went, unfortunately. And then here are my references.